So good day everyone. So at this point we have reached our last topic for our mid 1 OT or professional growth and development subject. So we are going to talk about, we have two topics that we to talk or discuss during this video. We have the crimes which will be encountered by the midwives or when we are practicing our professions, as well as the contracts that we will have on our future endeavors. So first, we're going to define what is crime and the criminal law. So criminal law is a law or a branch of law which defines crimes and treat of their nature, as well as it is the one that provides punishment for the commission of that crime. While crime is an act or omission which is punishable by law. So there are two kinds of crime. We have the felony and misdemeanor, or what you call the offense. So felony are crimes punishable by the revised penal code, or a crime of serious nature, such as yung mga murder, homicide, abortion, theft, simulation of birth are just one examples of felony. While offense or misdemeanor is an act or commission that is punishable by law, but not the revised penal code. So usually this is a less serious offense, less serious nature, and usually punishable by fine or a short-term jail sentence lang. So 1 day to 6 months, that is the misdemeanor or offense. While felony, most of the time, mga grave offenses ito siya, it is punishable by reclusion perpetua. Dati, nung applicable pa ang death, some of the crimes under felony is punishable by death. So what are the essential elements of felony? So first, there must be an action, or commission of an act. So pag sinabi nating act, it means any bodily movement which tends to produce some effect in the external world. Physical actions. That is what you call by act. Second, the act or omission must be punishable by the revised penal code. So, there is this rule na sinasabi that there is no crime when there is no law punishing the act. How will you say that this is the crime if it is not defined as a crime? So, in Latin, it says that nullium crimen nulla pena sine lege, or there is no crime when there is no law punishing the act. That is the rule. Third, the act is performed or the omission is incurred by means of dolo or malice, and or culpa, meaning fault. So, omission, when we talk about omission, it says that inaction or failure to perform an act required by law to be done. Yung wala kang ginawa na dapat sana gagawin ng isang taong with sound mind, or kung ikaw ay professional na dapat sana ginawa mo as professional, that is omission. Well, pag sinabi mo namang dolo, it refers to actions with malice or merong criminal intent. Criminal intent or intent to do evil to another individual, his property, as well as his rights. So, kapag merong dolo yung isang actions or yung isang crime, that is what you call intentional felony. So, there are requisites for dolo. Siyempre, pag merong intentions, dapat merong freedom first. So, the crime was committed freely by the person, by his own will, and that he did not act under any compulsion or under sa panunulsol ng ibang tao. Siya mismo yung nag-decide. While in second requisite is the person should have knowledge, intelligence. He must know what he is doing or what he is omitting to do. He knows what would be the consequences. The person must have his comprehension of the morality of what he is doing, and although knowing that it is punishable, although he knows na masama yung gagawin niya, he or she still decides to do it. That is intelligence. And lastly, for dolo to be considered, meron siyang intent. intention. So the person must have a criminal intent to do an evil or cause injury to another. So remember that one who acts without freedom necessarily has no intent to do an injury to another. One who acts without intelligence has no intent. But a person who acts with freedom and intelligence may not have the intent to do the injury to another. So before we proceed with the classification of felony, I would just like to include, kanina I defined the dolo as well as the requisites for to be considered a dolo or an action which has intention. So I also mentioned that meron tayong dolo and culpa. Pag sinabi mong dolo, acts with malice, and culpa is fault. Or culpa means fault. So, for example, when the offender commits a wrongful act which results in imprudence, negligence, or lack of foresight, or it includes lack of skills, the act is called culpable felony. So the main difference between intentional felony and culpable felony is that in intentional felony, there is criminal intent. While in culpable felony, there is no malice or criminal intent. But still, meron pa rin pong injury na nagawa. So yun po yung difference. Dolo is with intention, culpa, no intentions, but still merong damages or fault na nangyari. So proceed sa classification of felony according to the stages of execution. So there are 3 stages of act of executions of felony, and they are attempted, frustrated, and consummated stage. So what do we mean by attempted? Attempted felony is a felony that is done attemptedly. Balak pa lang po. When the offender commences the commission of the felony directly by overt acts and does not perform all the acts of execution which should produce the felony by reason and some cause or accident that his own spontaneous desistance. So if a person does not perform all the acts of execution but his own spontaneous desistance, there is no attempted felony. So when we say attempted or balak pa lang, does not perform all the acts of execution. Kung baga pa, he planned to do it but hindi niya nagawa totally. Pag sinabi naman nating frustrated felony, when the offender performs all the acts of execution which would produce the act of felony, but which nevertheless do not produce it by reason of causes independent of the will of the perpetrator. For example, pinakamadaling example. For example, I am the offender. Meron akong binaril na tao. Binaril ako, may binaril ako, yung binaril ko natamaan, naging critical sa hospital. But because of our technology ngayon, nabuhay yung binaril ko. So that is what you call frustrated. I execute the plan, ginawa ko yung crime, but then hindi ko lang na-reach yung goal ko na mamatay yung individual. That is frustrated. While consummated naman is a felony when all elements necessary for its execution and accomplishment are present. Binaril ko at namatay, that is consummated felony. Sinasadya ko at na-accomplish ko yung goal. Ulitin ko, attempted, binalak. Frustrated, binalak, ginawa, hindi na-reach yung goal. While consummated, merong balak, may intentions, na-execute yung plan, na-reach yung goal. So that is the classification of felony according to stages. So there are also classification of felonies according to their gravity. So the gravity of felonies is determined by the penalties attached to them by the law. And according to their gravity, felonies are classified into three, which is the grave felony, less grave felonies, and the light felonies. So grave felonies are those which the law punishes with capital punishment or with any of the afflicted penalties. Such as, nung dati meron pang death penalty. Yan na yung capital punishment na meron tayo. Afflictive penalties includes reclusion perpetua, which is imprisonment from 20 years and 1 day to 40 years. Meron tayong reclusion temporal, which means imprisonment from 12 years and 1 day to 20 years, while prison mayor is imprisonment from 6 months and 1 day to 6 years. That is what you call the prison mayor. Second, less grave felonies are those which law punishment with any correctional penalties. So correctional penalties includes prison correctional, which is imprisonment, prison correctional, which means imprisonment from 6 months and 1 day to 6 years. Destierro is a restriction of freedom from 6 months and 1 day to 6 years, while arresto mayor is imprisonment from 1 day to 6 months. Kindly correct that. 1 day to 6 months, that is arresto mayor. And for light felonies naman, which are those that are punished by law with arresto menor or with a fine not exceeding 200 pesos or both such imprisonment. So, pag sinabi mong arresto mayor, this is an imprisonment or a deprivation of freedom from 1 day to 30 days. That is arresto menor. Next, legal maxim. When we talk about legal maxim, it refers to an established principle or proposition of law. That is what we call the legal maxim. So, meron tayong actus non facitrium nisi mensit rea, meaning the act itself does not make a man guilty unless his intentions were so. Kaya nga meron tayong mga justifiable circumstances, exempted circumstances, because pwedeng may mga actions siya that results to damages but without the intention. Kagaya doon sa midwife, sa the midwives, nung hiniwa niya yung tiyan. Kahit na hiniwa niya yung tiyan at sabihin natin may that is the reason that caused the death of the mother. But he or she has no intentions of killing the mother, but yung intention niya is to save the life of the baby. Another legal maxim is actus me in vito factus non est meus actus. Meaning, an act done by me against my will is not my act. In Tagalog, yung ginawa ko na hindi ko gusto dahil I am forced or may balak niya, may threat ako na papatayin niya ako at ginawa ko ito, hindi ko yun gawa. For example, I have seen a story in Ipaglaban Mo. When yung kanyang boss or yung amo, kasi merong hardinero and katulong, and yung amo niya is a form of addict. Ngayon, ang ginawa ng amo is kinulong niya sa kwarto yung katulong and yung hardinero. And yung amo, finorce niya ngayon yung hardinero na i-rape yung katulong. Yung pag-rape, yung paggamit ng hardinero doon sa katulong is against his will. Ayaw niyang gawin, but because he is threatened by his boss, hindi niya kagustuhan, still ni-execute niya, but then it is not defined as his own action because he is only under threat. That is what actus me in vito factus non est meus actus means. An act done by me against my will is not my act. Next, we have person criminally liable. Meron tayong principal or in layman's term yung mastermind. So, a person who took part of the crimes, yun yung example of principal. So, a principal must have a direct participation or taking a direct part in the execution of the felony. Siya po yung nag-execute mismo, that is principal. A principal could also have induction or directly forcing others to commit a crime. Yan na po yung example ko kanina sa amo and yung hardinero. The principal is the amo because he is the one that forced the hardinero to do the rape or sexual intercourse with the maid against his will. So, therefore, the amo is the principal. And indispensable cooperation or by cooperating in a commission of the felony by another act without which the crime would not have been accomplished. Parang participation pa rin. Necessary cooperation. Without your action, hindi po masasakatuparan yun. That is considered as principal. For example, halimbawa ako, I am only 14 years old. Nabuntis ako. Siyempre, takot, minor de edad. I ask my mother na mabuntis ako. Siyempre, galit ang nanay. Nakakahiya ito, ipa-abort. So, punta kami ngayon sa midwife. Yung midwife is tumatanggap ng abortion procedure. So, the abortion was done. The mother and the midwife are considered principal of the crime. The mother, because siya yung nag-induce ng abortion. Siya yung may gusto ng abortion. And the midwife is also a principal because she has a direct participation on the crime committed. Aside from that, without her participation, there can be no abortion. So, dalawa yung principal doon sa crime na yon. The principal of induction as well as the principal of direct cooperation. Next, we have this accomplice. Accomplice or what we call accomplices. When we say accomplice, it refers to persons who are not principals. They are not the one who personally made the crime, but they cooperate in the execution of the felony by previous or simultaneous act. So, accomplices are also called accessory before the fact. So, accessory, yung mga accessory individuals or accessory of the crimes, pwedeng maging forfeit, yung mga reasons nila is forfeiting themselves, profiting themselves, yung ba may makukuha silang kabayaran, or assisting others to profit. Uulitin ko, pag sinabi mong accomplice, they are accessory before the fact. For example, ibalik natin doon sa example, paano ka nagiging accessory? Kanina, sabi ko nga, si Lina, ako is 14 years old. Yung nanay ko, pinilit akong magpa-abort. Pero wala kaming kilalang midwife. Wala kaming kilalang midwife na nag-undergo ng abortion. Ngayon, yung nanay ko, pumunta doon sa kaibigan niyang Marites. Si Marites, maraming connection. Ngayon, si Marites, pumunta doon sa kaibigan niyang midwife, for example. Yung midwife na yun ay, nag-refer siya. May kilala akong doktor, pero sikreto lang. Bigyan mo lang ako ng komisyon. Ganito, may bayad na ganito, ganyan, ganyan, ganito. Siya yung nag-refer sa doktor na yung doktor is gumagawa ng abortion. The midwife ngayon is considered accessory before the fact. Because she is the one that introduced or referred the victim to the offender. That is a sample of accessory before the fact. Accomplice. Hindi kumbaga pa necessary yung actions niya before gawin yung actions. Next, we have this accessory. So, accessory are persons having knowledge of the commission of the crime and without having participated therein. Hindi po ibig sabihin na hindi ka nag-participate, wala ka ng liability. Halimbawa, ikaw na midwife ka at alam mo na yung kaibigan mong midwife ay may ni-refer for abortion. Alam mo na may ginawa siyang abortion sa minor and yet wala kang ginawa, na nahimik ka lang. tapos humingi siya ng tulong sa'yo na natapos na yung abortion, pwede bang dyan muna sa'yo yung mga gamit para hindi makita. You are still considered as accessory. Usually, accessory after the fact. Still, you take part after the crime was committed in any of the following manners. For example nito, by profiting themselves or assisting the offender to profit by the effects of the crime. May kinita siya doon, nag-assist ka. That is accessory after the fact. By concealing and destroying the body of the crimes. Pag tinago mo yung mga nurses' notes, sinunog mo yung mga ebidensya, you are still considered as accessory. By harboring, concealing, or assisting the escape of the principal. Hinayaan mong makatakas yung principal of the crime, provided the accessory acts with abuse of his public function or whenever the author of the crime is guilty of treason, parricide, murder, or any attempt to take the life of chief executive or is known to be habitually guilty of some other crime. So we're done talking about the liability of a person. So meron tayong principal, meron tayong accessory, and the accomplice. Principal could be principal of induction, principal of direct participation, and principal of indispensable cooperation. Yun yung tatlong klase ng principal. While accomplice naman is also termed as accessory before the fact. Hindi sila yung principal but nag-cooperate sila for the execution of a felony. While accessory naman, they are the person who participated after the execution. Pwedeng nagtago ng mga ebidensya, nanira ng mga ebidensya, or nagpatakas doon sa krimen, sa kriminal, doon sa offender or nag-execute ng crime. And we have this term, conspiracy, or in Tagalog is kasabuat. So when we say conspiracy, it exists when two or more people come to an agreement concerning the commission or execution of a felony and they decide to do it. So these are two or more person agreed and committed the felony. Therefore, each of the criminal is responsible for the acts of his associates provided such act is a result of a common plan. They both decided, they both planned the felony. So they are considered as conspirator in the event of conspiracy. Circumstances that affects a criminal liability of individual or events that could lessen the penalties or punishment or could be exempted in the civil and criminal law liability. First, we have the justifying circumstances. So these are those where the act of a person is said to be in accordance with the law. Hence, he incurs no criminal liability or civil liability. So, the following are justifying circumstances. So, anyone who acts in self-defense of his right, from the word self-defense. Second, anyone who acts in defense of his relative, in the rights of his relatives. That includes his husband or wife, kanyang parents, anak, or brothers and sisters. Third, anyone who acts in defense of the right of any person, stranger. Nagbabago lang itong circumstance na ito kung yung individual na nag-cause ng damage to another individual has the intention of revenge, meron siyang resentment or personal grudge doon sa tao. Pwedeng magkaroon ng ibang circumstances. For example, binugbog ka, nagkaroon ng commotion. Hindi ka nanlaban. Tapos yung sumuntok sa'yo o yung bumugbog sa'yo, tumakbo, hinabol mo, ngayon inabutan mo, nabugbog mo at napatay mo. Ibang case na po yun. That would not be a justifying circumstance. But, for example, ikaw nagtangkaan kang patayin, nanlaban ka at napatay mo, that could be a justifying circumstance. Pero once na umalis na, tumakbo at hinabol mo, hindi na po yun siya justifying circumstance. Third, Fourth, rather, any person who acts in the fulfillment of a duty or in the lawful exercise of a right or office. So these are the kadalasan nangyayari sa ating batas or sa mga policemen. Minsan nakakapatay sila, that is illegal killing, wherein the damage has been done due to fulfillment of his work or his duties or obligations. Next, we have any person who, in order to avoid evil or injury, does an act which causes damage to another. State of necessity, kinakailangan. In order for you to prevent a larger injury or a bigger damages, you had done something that damaged a certain or injured a certain individual. So that is what you call the state of necessity. And lastly, any person who acts in obedience to order issued by a superior for some lawful purposes, or the obedience of the superior order. So in this last requisite, it is required that the order itself must be lawful in accordance to the law pa rin. Next, we have the exempting circumstances. From the word itself, exempting, meaning a person is exempted in criminal or civil liability. Are those grounds for exemption from punishment because of the complete absence of intelligence or freedom of action on the part of the accused. Wala pong requisite for dolo. Ano yung tatlong requisite? Intelligence or knowledge, freedom of action, and the intention. So, strictly speaking, in exempting circumstances, a person acting or commits a crime but cannot be held liable. So, here are the factors or circumstances under exempting circumstance. First, we have the imbecile or insane. May mental incapacities yung isang tao. Problema sa utak, baliw. They are exempted. Bakit po? They don't have the knowledge, the intelligence. Second, minority. 9 years old and below don't have the enough knowledge of committing such crime, and they don't have enough knowledge or discernment to judge their actions. Persons over 9 years old but under 15 years old is under exempting circumstances pa rin. Unless na lang when the felony or crime committed is done with discernment. Next is force majeure. So, pag sinabi natin force majeure, it is accidents. Accidents. So, here, a felony or a crime is under exempting circumstances if the offender performs an action under a lawful act. The action is done with due care. The cause of injury to another is merely accident, and the act has no fault or no intention of causing an injury. That could be exempting circumstances. Next, a person who acts under an impulse of fear of an equal or greater injury. So, compulsion of irresistible force, for example nito, coercion, pinilit ka. That is an example of exempting circumstances. Compelling someone, you are compelled by your superior, threatened by your superior. It is only applicable, it is only exempting if the danger itself is present and not fictional. Nakatutok sa iyo yung baril, for example. And remember doon sa pinag-usapan natin yung legal maxim, yung regarding sa free will. Sabi dito, so under dito, sa person who acts under the impulse of fear, meaning he or she doesn't have the free will. The free will, or it is against his act. And balikan natin yung legal maxim natin na act actus me invicto factus non est meus actus, which means an action done by me against my will is not an act. Therefore, it is under exempting circumstances. Lastly, any person who fails to act required by law when prevented by some lawful or insuperable cause. Third circumstance is the mitigating circumstance. So what does this mitigating circumstances? So these are those which are present in the commission of the crime do not free the offender from criminal liability but serve only to reduce the penalty of a crime committed. So this is opposite of the fourth circumstances, which is the aggravating circumstances. Meaning the nature of the crime does not change. Ganun pa rin po yung crime na nagawa niya. But the penalty is decreased, or these are factors that provide reasons as to why punishment of that crime for the criminal acts ought to be decreased. So here are the circumstances. The offender is under 18 years of age or over 70 years old. That is under mitigating circumstances, or the punishment is lesser than the usual. The offender had no intentions to commit so grave a wrong as that committed. Wala po siyang intention that the final result would be the end. Hindi niya na-foresee yung result or yung consequence. Next, the sufficient provocation or threat on the part of the offended party immediately preceded the act. The provocation was started by the offended party. Sila yung nagsimula. Na-provoke ka lang. That could be a mitigating circumstance. Mas mababa yung sa'yo, mas mababa yung magiging parusa sa'yo kasi nga you were provoked. Next, the act having acted upon an impulse so powerful as naturally to have produced passion or obfuscation. And next, the offender had voluntarily surrendered himself. Mas mababa po yung magiging punishment, or nag-plead siya ng guilty. That is under mitigating circumstance. The offender is deaf, dumb, blind, or otherwise suffering from physical defects which restricts his action, defense, communication with his fellow beings is also under mitigating circumstance. Another is aggravating circumstances. As I've said, this is opposite to the mitigating circumstance. Kung ang mitigating is decreasing the punishment or decreasing the penalty of the crime committed, aggravating naman is increasing. These are factors that increase culpability or fault. So, na-aggravate niya yung ginawa mong mali or yung crimes. Therefore, mas harsher yung magiging penalty. So, if the attendant to the commission of the crime serve to increase the liability of the offender, first, we have if the person or the offender uses the advantage of public position. He used his or her profession in committing such crime. Second, the crime committed during nighttime or inhabited place, walang tao. So, ibig sabihin nun, it is planned. It is intentional. Next, with the aid of armed men or person who ensure or afford immunity. Gumamit ka ng iba. This could also use hired killers. That is also under aggravating circumstances. And consideration of price, reward, or promise. Committing a crime with the intention of profiting. Kikita ka dun. That is aggravating circumstance. While alternative circumstances naman, these are circumstances that must be taken into consideration as aggravating or mitigating according to the nature of effects of the crime and the other conditions attending its commission. So it is either aggravating or mitigating, depende sa situation. So there are conditions that could determine if the crime is aggravating or mitigating. First is the degree of instruction of the offender. So for example, a low degree of instruction or lack of its generally a lack of understanding is generally mitigating circumstances. High degree of instruction and education, ibig sabihin, if you are a professional, for example, you have studied, you have a degree, that could be an aggravating circumstance because you are aware the offender avails himself of his learning in committing the crime. He has knowledge and free will. He has a sound mind and better understanding of a situation. Therefore, the acts committed is aggravating circumstances. Second, intoxication. So it is mitigating under intoxication if intoxication is not habitual and not subsequent to the plan to commit a felony. Hindi ka po sanay sa inom, first time mong nag-inom, it affects your mental capacity. Nagbabago, hindi mo alam yung ginawa mo kasi intoxicated ka. Kung first time mong ginawa, that could be a mitigating circumstance. But if it is habitual to you na umiinom ka na, therefore your body is adjusted with alcohol, that could be aggravating. At the same time, if ang reason mo is uminom ka para magpalakas ng loob kasi may gagawin ka, that could also be aggravating circumstance. And lastly, the relationship of the offender to the offendee. For example, if directly related sa iyo yung offender, like your father, parricide, rape of your ascendant or father, lolo mo, that could be an aggravating circumstance. So here are some of the crimes. Here are the crimes. Depende po against a person, against a property, chastity. So some of these are already discussed. So murder, homicide are both killing a person. But in murder, meron po tayong tinatawag na mga conditions for a killing of a person to be considered as murder. And murder is a non-bailable, kumbaga pa. If you are accused of murder, it is a non-bailable crime. Hindi po pwede yung piyansa and it is punishable by capital punishment. So, murder is committed by any person who kills another person with treachery, panlilinlang. There is a consideration of price, reward, or promise by means of inundation, by fire or poison, explosion, shipwrecks, derailed or assault upon a streetcar, pagpapasagasa. That is an example of murder. With evident premeditation, intention, planned. And syempre with cruelty. So now we are going to talk about the different crimes which is punishable by law. So first, we have a crime against a person. Crimes committed against an individual. So we have here first the murder. So murder is killing a person who kills another person with qualifying circumstances. Ano po yung mga qualifying circumstance? Treachery. Taking advantage of superior strength, meaning yung individual is walang kakayahan o opportunity na i-defend yung sarili niya. Sinaksak mo siya ng patalikod, pinatay mo siya ng patalikod, that is considered murder. Advantage of superior strength, for example, marami kayo, that is considered as murder. Aid with armed men. Merong plano, that is also considered as murder. And syempre with cruelty or by deliberately and inhumanely augmenting the suffering of the victim. Pinahirapan mo yung biktima mo. That is murder. While homicide is the person of killing. Is a person killing another person. Pareho po silang pumapatay. But homicide is without the requisite of wala siyang qualifying circumstances that was mentioned in the murder. Wala siyang treachery, walang advantage of superior strength, hindi siya planned, it is considered homicide if merong unlawful killing of another person as long as walang qualifying circumstance and hindi siya ma-fall sa parricide, murder, infanticide, or self-defense. That is homicide. Next, we have the euthanasia, or commonly known as mercy killing. So, painlessly putting an end to the life of a terminally ill patient or patient suffering from incurable disease. Hindi na po magagaling. And dito sa Pilipinas is hindi po yon pwede. That is against the law. Lalo na if the patient does not want to die while in giving assistance to a suicide. The person wants to die. Yung sa euthanasia, wala siyang order na gusto niyang mamatay. Next, we have assistance to suicide. Giving assistance to suicide is committed either by assisting another to commit suicide, whether yung suicide na yun is consummated or frustrated. Still, if you have done something to assist it, you are guilty of crime against a person pa rin. And by lending assistance to another to the extent of doing or killing himself. That is also a crime. Next is parricide. Pag sinabi mo namang parricide, is committed by a person who kills his father, mother, or legitimate or illegitimate brother or sister. Any of his ascendants, descendants, or his spouse is considered parricide. Next is infanticide, killing of a child less than 3 years old. So the penalty is the same as that of parricide or murder. Capital punishment po yung nangyayari kasi they are aggravating circumstance. Next is abortion. So it refers to the expulsion of the fetus from the forceful expulsion of the fetus from the womb before it is viable. So we have different types of abortion. May intentional abortion, may unintentional abortion, abortion practiced by the woman upon herself, or abortion practiced by parents of the woman with her consent, and abortion practiced by a physician or a midwife. Next is mutilation. Mutilation is a crime against a person that is deliberately lopping or clipping off some part of the body of another person with the purpose of depriving the person of the part of his body. For example nito is yung pagputol ng penis ng inyong manlulokong asawa is a form of mutilation. So, mutilation is considered as physical injury and a crime against a person because you are restricting. You have a deliberate intent of depriving a person of that specific part of his or her body. So, as I've said kanina, mutilation is under physical injury. So, physical injury can be classified into serious physical injury, less serious physical injury, and slight physical injury. Serious physical injury consists of wounding, beating, assaulting, and administering injurious substances. Yung mga substance that can cause injury, yung mga abortifacient, pwede po yun maging, or lason, pwede po yun, to another person which may be committed by reckless imprudence or negligence. Sa simpleng katangahan mo at kapabayaan mo, pwede ka pong mag-cause ng serious physical injury. So the harm or injury inflicted on a person will be considered serious physical injury when the injured person becomes insane, imbecile, impotent, or blind. Kung yung pagkakamali nagawa mo or yung injury, yung damages doon sa offended party caused him to be insane, caused him to be impotent, or nabulag, nagkaroon ng restrictions. It could also be a serious physical injury if the person injured loses the use of speech, power, or the senses. If he loses a foot or arm or leg, becomes incapacitated for the work in which he or she is habitually engaged. Hindi na niya kayang maging productive at magtrabaho, that could fall to a serious physical injury. The person injured becomes deformed or loses any other member of his body, becomes incapacitated or ill for the performance of work is considered, or the felony or crime could be under serious physical injury. Less serious injury naman is a harm or injury inflicted on a person which incapacitates the person for labor for 10 days or but not more than 30 days. So it needs medical attendance for the same period of time. Nabalian, pwede yun. At hindi siya makapagtrabaho ng ilang linggo. That is less serious physical injury. While slight physical injury naman is injury or harm inflicted on a person which incapacitates the offended party from 1 to 9 days or requires medical attendance during the same period. So slight physical injury may be committed by ill treatment of another person and the evidence of actual injury may not be present. Pwede mo siyang ibilong sa slight physical injury. Next, rape. Dati, yung hindi pa nagkakaroon ng revised penal code, rape is a crime against chastity. But based on the definition natin kasi ng rape is a felony committed by a man who has carnal knowledge of a woman under the following circumstances. Merong force, coercion, or threat. Basta gumamit ka ng force to have a sexual intercourse with someone, that is considered rape and a crime against a person. So it is considered rape kapag yung sinabi ko kanina, merong force, threat, or intimidation. Takot. When the offended party is deprived of reason or otherwise unconscious. Lasing, pinatulog mo, ginalaw mo, that is considered as rape. By means of fraudulent machination or grave abuse of authority. Kasi boss ka. Bibigyan kita ng ganito. That is considered rape. And when the offended party is under 12 years of age or is demented, even though none of the circumstances mentioned above are present. That is considered rape. Also, pwede rin nating makonsider ng rape if yung penis of another person is put inside the mouth of an individual or doon sa kanyang anal orifice. That is also considered as rape. By inserting any instrument or object into the genital or anal orifice of another person under any of the following circumstances. Through force, threat, or intimidation. Same as with yung doon sa na-mention kanina. Next, we have the crimes against liberty and security. So, kalayaan at saka yung iyong safetyness. So, first, we have the illegal detention. So, it is a crime committed by a private individual who unlawfully deprives another person of his liberty or kalayaan niya. This may be committed by a hospital personnel who refuse to discharge patient and would not allow them to leave because of non-payment of hospital bill. Kaya po, bawal yun. Hindi kayo pwedeng sabihan ng hospital na ay bawal kayong lumabas kasi hindi pa kayo fully paid. Next, abandonment of person in danger. This is a crime committed by anyone who fails to render assistance to any person whom he finds in an uninhabited place, wounded or in danger of dying, when he can render assistance without detriment to himself. Kapag may nakita kang krimen, for example, meron diyang babaeng lupaypay, hinang-hina, duguan, dinaanan mo lang, wala kang ginawa, nakita mo kasi natakot ka. Alam mong walang lakas yung babae, that could be a crime against liberty and security. Abandonment of one's victim. Yung mga biktima ng hit and run. Kung ikaw yung driver nun, that iniwan mo yung nasagasaan mo, that is a crime against liberty and security. And pwedeng maging cause ng pwede pang maging aggravating circumstance yun. Lie threats, pananakot, means a threat to commit a wrong not constituting a crime. Although hindi mo siya na-execute. Bribery. Pangingikil is also considered as light threats. We have grave threats. So grave threats are committed by any person who shall threaten another with the infliction upon the person, honor, or property of the latter or of his family of any wrong. So a midwife who threatens a hospital director that she will publish a newspaper to a newspaper the evidence of graft and corruption committed by a hospital director, if the latter does not accept her job application, may be charged of grave threats. Pananakot. Grave coercion naman. Grave coercion can be committed by a person either by preventing person by means of violence, force, for doing something not prohibited by law, or compelling another by means of violence or force to do something against his will. That is grave coercion. And aside from that, revelation of secret. Kaya nga meron tayong confidentiality. Hindi po tayo pwede maglabas ng mga sikreto, lalong-lalo na po ng pasyente natin, especially yung conditions nila, because that could be a crime of against liberty and security of an individual. Next, the crime against property. Ano naman po ito? For example, robbery, theft, swindling, or estafa. Pwede rin po arson. So, hindi ko na po siya i-discuss since it was already discussed during our midterm. Crimes against chastity naman includes adultery, which is a crime committed by a married woman who has sexual intercourse with a man not her husband, and by the man who has carnal knowledge of her. Alam ng lalaki na may asawa siya. Concubinage naman is the opposite of adultery, which is committed by a married man who either keeps a mistress on a conjugal wedding, sexual intercourse under scandalous circumstances, cohabits with a woman not his wife in any other place. That is concubinage. Adultery kapag babae ang nanloko, concubinage kapag lalaki yung nangabit. Acts of lasciviousness. So, acts of lasciviousness refers to an act or conduct that is lewd or lascivious. Means lustful. Or tending to produce voluptuous or lewd emotions. And the term lasciviousness comprises all acts of lasciviousness performed upon a person of either sex short of lying with a woman and anything leading up to it, independently of the intention of the wrongdoer. Next, we have the seduction. Seduction means withdrawing a person from the path of rectitude. So, as a felony, it may be simple or qualified. So, simple seduction refers to seduction of a woman who is single or a widow with a good reputation. While qualified seduction naman is a seduction of a doncella or virgin over 12 years and under 18 years of age. So, minor. That is seduction. Qualified seduction. So, committed by any of the following: any person in public authority, including the priest, yung home servant natin, domestic guardian or teacher. That could be a qualified seduction. Any person who in any capacity shall be entrusted with the education or custody of a woman seduced, or any person who seduced her sister or descendant, whether or not she is a virgin or 18 years of age, can fall into qualified seduction. And lastly, under crimes against chastity is the abduction. So, abduction refers to the kidnapping of a woman by removing her from her home. So, meron tayong forcible abduction, from the word forcible, used with force. So, you are abducting a woman against her will. While consented abduction naman, as a felony, is the abduction of a virgin over 12 and under 18 years of age, carried out with her consent. Although may consent siya, but still, consented abduction yun because the woman is still considered as minor. Crimes against civil status of a person. Dito na po papasok yung simulation of birth, substituting one child for another, and concealing or abandoning a legitimate child. Crimes against honor. We have defamation. So, pag sinabi mong defamation, ito na yung tarnishing. Tarnishing the dignity of another person. So, there are two types of defamation. Merong slander and merong libel. Pag sinabi mong slander, this is oral defamation. While libel naman is a written defamation. Quasi-offenses. Pag sinabi natin quasi-offenses, when we say when we say quasi-offenses, these are negligence or unlawful act that causes injury or loss to another, or a situation which the law imposes an obligation for the damage that was caused. So, ito na yung tinatawag na civil offenses. So, under these quasi-offenses, it could also, usually, it is an tort of negligence. So, first, we have the simple imprudence. So, simple imprudence consists in the lack of precautions displayed in those cases in which the damage impending to be caused is not immediate, nor the danger clearly manifested. Salita, pag sinabi mong simple imprudence, the person did not use precautions, hindi po nag-ingat, and damage or yung injury was not immediate, hindi agad nag-manifest. While reckless imprudence refers to voluntarily but without malice, actions which done voluntarily but without malice, or doing or failing to do an act from which material damage results by reason of inexcusable lack of precaution on the part of the person performing or failing to perform such act, taking into consideration his employment and occupation, degree of intelligence, physical condition, and other circumstances regardless of person, time, and place. So when a person does an act or fails to do it voluntarily but without malice from which material damage results immediately is under reckless imprudence. So next we have the midwife and the contract. Pag sinabi nating contract, it is a binding agreement between two or more person. For our civil code, contract is defined as meeting of the minds between two persons whereby one binds himself with respect to the other or to give something or to render some services. Mutual understanding or mutual agreement. So here is the following principles. Meron tayong tinatawag na do ut des. I give that you may give. Meaning, I give you my service and you give me compensation in return. For example, reciprocity. Pag may binigay ako sa iyo, I expect that you to give it back to me in terms of services. If I give you service, you pay back to me in terms of monetary value. Next, we have do ut facias. When we say do ut facia, it says, I give that you may do. Sinasahuran kita para magtrabaho is an example of do ut facias. I give that you may do. Nagbayad ako sa services mo, therefore, you should, or you are entitled to give me your services back. Facio ut des naman, I do that you may give. And facio ut facias is, I do that you may do. Take note of this. Because I assure you, lahat po ng mga Latin terms ilalabas sa exam. Obligations. Ano naman po itong obligation? Juridical necessity to give, to do, or not to do. So, an obligation is only juridical when it can be enforced by law. So, obligations arises from law. There are kinds of contracts. So, informal contracts are type of agreements that will not require any sort of legal intervention to be considered enforceable. So, it is one that does not require a record or it doesn't need to be signed. So, any other form of contracts are called contracts except for those who needs to be signed by an attorney. Yung hindi siya marriage contract. So, informal contract can be given oral or written. Formal contract naman is a contract which requires special formalities or a certain specified form in addition to consent, subject matter, and cause before the contract may be perfected. So, itong formal contract, halimbawa nito is yung marriage contract, deed of sale. Yan yung mga example ng ating formal contract. While implied contract naman, I believe it was already explained. So, a contract that is conducted as a result of acts or conduct of the parties to which law ascribe or the law it exists So it is an object intention to enter into a contract. Meaning, if I am a midwife, I applied into the hospital, the employer does not need to inform me that my duty is to render service, or my duty is to take care of my patient, because that is already implied and expected as a midwife. It is expected of me to take care of my patient. While express contract naman is a contract which conditions or terms are expressed orally or in writing by parties concerned. We also have this void and inexistent contracts. These are contracts that has no effect at all and which cannot be ratified or validated. Void, walang bearing. Illegal contracts naman are contracts contrary to the law. Halimbawa nito is may nagpabili sa iyo ng bata, pinapirma mo yung nanay na binibili mo itong bata o binayaran mo yung nanay ng ganitong halaga. That is illegal contract because selling of a person or a child is prohibited by law. Therefore, kahit na may pinirmahan siya sa iyo, kahit na pinanotaryo mo pa yan or anong ginawa mo dyan, that is considered as illegal contract. So, we are at the end of our final lecture for Mid 103. I hope you have learned something. Again, take note of the Republic Acts, the Latin terms for the laws, definition of terms. That all would be included in our final exam. I've sent 2 videos including this one. Yun po yung magiging coverage ng ating final exam. Again, thank you and good luck for your future endeavor. This would be our last encounter. So good luck on your final exam. I hope we all end this semester with a smile. Thank you and God bless.